Every day in the USA, people find themselves in court.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Wendy Scott. It's case number 2024 CR 346. James Watts appears as defense counsel. Wendy Scott appears from the Butler County Detention Facility's Zoom location. Amber Norris appears for the state of Kansas. This matter comes before the court at this time for pretrial conference. Court noting that the matter last came before the court on October the 30th. An evidentiary preliminary hearing was held. At that time, the state had moved to amend count 1 to aggravated kidnapping and count 5 to felony theft. Those requests were granted. The court found probable cause on all 6 charges. At arraignment, the defendant waived reading, entered a not guilty plea. Pretrial conference was set for today, with jury trial set to begin on February 25 at 9 o'clock. Requests for furlough and bond modification were denied by the court. With that recap, Mr. Watts, what is the current status of the case and what announcement is made?
Your Honor, the state had made an offer in this case, an offer that's consecutive, or not consecutive, it's the same as the offer made the co-defendant, Ms. Rogers. My client, I understand, wishes to enter a no contest plea accepting that offer. That offer is to count 1 as originally charged, which is kidnapping as a level 3 offense, as well as count 3 and count 4, all concurrent mid-box. We do reserve the right to seek departure. I assume the state will oppose that departure. I would expect the state would oppose that departure. I think that's all I have, Your Honor. Thank you.
All right. I want to make sure that I'm aware of what charges your client's conceivably going to be pleading to. Count 1 then would be kidnapping, a level 3 person felony. Count 3, criminal threat, a level 9 person felony. And count 4, aggravated robbery, a level 3 person felony. Is that your client's intentions?
Yes, sir.
All right. Ms. Norris, has Mr. Watts announced consistently with your understanding as to how the Scott case would be handled?
Yes, Your Honor.
All right. Ms. Scott, I've got a number of questions I need to ask you regarding the taking of a felony plea. If there is any question asked of you that you do not fully understand, I would give you the opportunity to confer privately again with your lawyer at any point if you need to get further advice along the way. Okay?
Yes, sir.
Just let the court know if you need that time.
Yes, sir.
I'm going to start off by having you state your full legal name for the record.
Wendy Sincere Scott.
How old are you right now?
I'm 40 years old.
What's the highest level of formal education that you've attained?
11th grade.
Now, do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here this morning?
No, sir.
Have you ever been adjudged to be mentally ill?
I have depression, anxiety, depression. I take mental health meds for.
Are you getting those mental health medications in the jail?
Yes, sir.
Do they help you and improve your mental state?
Yes, sir.
Okay. All right. Do you believe you have a full understanding of what's going on here in court?
Yes, sir.
All right. And you can tell the court then that you're not under the influence of alcohol or any drug?
I'm not under the influence of anything.
All right. Now, did you receive a copy of the original charges in this case?
I think so. From the jail, I think that they gave me just a paper. It is like it was, yeah, when I first came, I still got that paper.
Okay. Do you understand the nature of the charge of kidnapping? That would be in amended count 1?
Yes, sir. Yes, sir.
Do you understand the nature of the charge of criminal threat in count 3?
Yes, my attorney explained it all.
Okay. as he should.
Yes.
And do you understand the nature of the charge in count 4, aggravated robbery?
Yes, sir.
All right. You understand that when you enter pleas of no contest, you are not necessarily admitting that you did these things, but you're
Ye-
also not contesting that you be convicted of these offenses just the same. Do you understand that? Ms. Scott?
Yes, sir.
All right.
I didn't know if you heard me. I'm sorry.
I did not. So I would appreciate if you'd speak up when you answer. I just want to make sure all participants can hear your responses to the court's questions.
Yes, sir.
All right. You further understand that when you enter pleas of no contest, you'd be giving up any legal defenses that you might have had to those charges.
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your attorney, Mr. Watts, and present evidence on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case and tell your side of the story, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes, sir.
You understand that when you enter pleas of no contest, you give up these valuable trial rights that the court has described.
Yes, sir.
Are you also aware that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, sir.
Understand that when you enter pleas of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, sir.
Do you understand, Ms. Scott, that you have a right to appeal a guilty verdict if you have a trial?
Yes, sir.
Do you further understand that you may appeal your sentence after entering pleas of no contest, but generally you may not appeal your judgments of conviction after you enter such pleas?
Yes, sir.
Are you aware of the possible sentence that could be imposed as a result of these pleas that you're attempting to make?
Yes, sir.
Let's go over those. Level 3 felonies in Kansas would be on the non-drug offense grid. In the most favorable criminal history category of I, you could receive as little as a 55-month prison sentence. In the worst criminal history category of A, you could receive up to a 247-month sentence. So the sentencing range for level 3 would be 55 to 247 months in prison.
Yes, sir.
A level 9 felony, such as the criminal threat, in the most favorable criminal history category of I, you could receive as little as a 5-month prison sentence. In the worst criminal history category of A, you could receive up to a 17-month sentence. So the sentencing range for a level 9 felony is 5 to 17 months in prison. Do you understand that?
Yes, sir.
You also understand that you could receive up to a $100,000 fine for a level 9 offense.
Yes.
You also understand that you could receive up to a $300,000 fine on a level 3 offense.
Yes, sir.
Ms. Scott, I need to point out to you that at level 3 on the non-drug offense grid, any level 3 crime would be presumptive prison under Kansas law. Do you understand that?
Yes, sir.
Do you understand the difference between consecutive and concurrent sentences?
Yes.
Let's go over that. Concurrent sentences mean that they run all at the same time. When you're serving one, you'd also be serving another. Obviously, that would result in a much shorter overall sentence. Consecutive sentences are boxcard, back to back. You have to serve all of one before you even start serving the next, which would obviously result in a much longer prison sentence. Do you understand, Ms. Scott, that regardless of any plea agreements that's been reached, it's up to the court to determine whether your counts run concurrently or consecutively?
Sir.
Ms. Scott, I also need to point out that the Kansas Sentencing Guidelines Act has what we call special rules. If any special rule applications would apply to you in your case, do you understand that it could affect your sentence or affect your ability to be put on probation. You understand this?
Yes.
All right.
I have a question. You said special rule?
Yes.
What did that, like a special rules, like if I haven't heard of a special rule on my case?
I don't know that one would apply, Ms. Scott. I
Okay.
just need to make you aware that the Kansas Sentencing Guidelines Act is just a big book of sentencing rules and laws. And among those, there are some special rules that sometimes come into play. Generally speaking, your attorney will be aware of special rules that might apply to your case, and he would have discussed those with you.
Okay. No, he
If
did.
he
And
didn't,
Your Honor,
okay, go ahead.
I'm sorry, Your Honor, I would note, I'm not aware of any special rule particularly that's likely to apply here. As far as I know, she's not on probation or parole at this time or anything, so I don't know that there's one that really applies here.
Ms. Scott, are you satisfied?
Yes, sir.
All right, then let's go further.
Mhm.
You also understand that in addition to any fines that might be imposed, you could be assessed and be required to pay court costs, certain fees, and restitution to victims, if any are owed, as part of your sentencing orders.
Yes, sir.
You also realize, as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes, sir.
You also understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, sir.
Some of those circumstances might actually exist here. Do you understand that?
Yes, sir.
All right. Now, Ms. Scott, do you feel like that you've had an ample opportunity to discuss legal matters and sentencing options fully with your attorney, Mr. Watts, before proceeding here today?
Yes, sir.
You want any more time with him privately now before we go further?
No,
All right. Are you satisfied with the services and advice given to you by your attorney?
I am.
Now, Ms. Scott, this no contest plea set that you're attempting to make, has this been based on any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No,
Ms. Scott, is there anything else that you thought was part of this plea agreement that hasn't been accurately discussed on the record already?
No.
All right. Do you understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made? The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
yes. So I have a question. So when we get plea agreements, we don't get that? We don't
It
get
doesn't bind the judge.
Oh,
It
okay.
binds the prosecuting attorney, perhaps might require her to make certain recommendations or remain silent on certain things, but it doesn't bind the court. That's what I want to make sure you understand.
Okay, yes.
All right. So, Ms. Scott, how do you formally plead to the charge in amended count 1, kidnapping, a level 3 person felony,
No contents.
and to count 3, criminal threat, a level 9 person felony,
No contents.
and to count 4, aggravated robbery, a level 3 person felony?
No contents.
All right. I'm going to ask the state for a concise, factual basis as to each charge.
Your Honor, on July 20th, 2024, the defendant did take Ms. Zilke by way of her vehicle from her apartment in Wichita into Butler County, where she did threaten to cause her harm and did forcibly remove her from her vehicle, the gray 2024 Nissan Altima, and did take that and her purse and a dog in the process and left her on the side of the road. And that was near 12928 Southwest 120th Street, Augusta, Butler County, Kansas.
Okay. The taking originally was accomplished by what means?
The taking of Ms. Zilke or the taking of the vehicle?
The taking of Ms. Zilke.
It was, they asked for a ride, and initially Miss Silky thought they were going to, was basically taking them to a hospital, and they kept giving her basically false directions, which led them into Butler County, and they kept giving her further directions that got them even deeper into Butler County. And she basically then was concerned. So basically they deceived her in where they were going. And then once Miss Silky figured or thought something was, it didn't seem right, then she questioned them, and then the threats and the taking of the vehicle and the other part of it occurred.
All right. So the taking of the person of Ms. Zilke was done by deception.
Yes, Your Honor.
All right. Now, the specific criminal threat, I understand that you mentioned threats, but what oral statements were made that could be construed as a threat under these circumstances?
Your Honor, they did have I believe they did have a firearm, and they did threaten to shoot her or do harm to her with the gun if she didn't well, if she didn't give them the vehicle or whatever else they wanted.
All right. Thank you. And I see that that same language is included in count 4 on the aggravated robbery charge. That they took the motor vehicle by force or threat of bodily harm. What was the bodily harm inflicted on Beverly Zilke?
Your Honor, she did have some scrapes and some bruises from where she was basically pulled from the vehicle and ended up in the roadway.
Okay. So they literally dragged her out of the car and
Yes, Your Honor.
put her on the ground?
Yes, Your Honor.
Oh, all right. Very well. All right, so Ms. Scott, at this time, are you making pleas of no contest freely, knowingly, and voluntarily, and accepting conviction for, in count 1, kidnapping, a level 3 person felony, count 4, aggravated robbery, a level 3 person felony, and count 3, criminal threat, a level 9 person felony?
Yes, sir.
Mr. Watts, do you know of any legal reason why the court should not accept this defendant's plea?
No legal reason, Your Honor. Thank you.
Ms. Norris, are you aware of any such legal reason?
No, Your Honor.
Wendy Scott, are you aware of a legal reason or any other good reason why the court shouldn't accept your pleas of no contest this morning?
No, sir.
Court will accept the no contest pleas made by Wendy Scott and finds that those pleas are made voluntarily. She has an understanding of the nature of her charges and the consequences of her plea, and a factual basis for the pleas does exist. The court finds the defendant guilty, and the judges are therefore convicted of the crimes of kidnapping, a level 3 person felony in count 1, criminal threat, a severity 9 person felony in count 3, and aggravated robbery, a severity level 3 person felony in count 4. All other charges of the charging document are dismissed pursuant to plea agreement. Court will order a pre-sentence report be completed to accurately determine Ms. Scott's criminal history, and the court will set an appropriate date for sentencing. Ms. Scott, if I had my preference, we'd go ahead with sentencing today, but we really can't do that. There has to be a research of your prior criminal history. That takes time. We generally allow about 2 months for completion of that report. If you're asked to do any assessments of any kind, I will expect you to fully cooperate with those assessments, but I will set a sentencing date about 2 months out, and then you'll be sentenced at that time. Counsel, that will put us mid to late April. One date I was looking at, Mr. Watts, was Friday, April the 18th at 1:15 p.m.
Yes, sir, I can do that.
All right. Ms. Norris, I trust that'll work for you.
Yes, Your Honor.
Sentencing in the Wendy Scott case will be Friday, April 18th at 1:15 p.m. Would you expect that there would be a victim statement?
Yes, Your Honor.
All right. I think we can still go ahead and conduct this proceeding by Zoom. I know Ms. Scott is in custody. And I do recall that Ms. Zielke is elderly. I believe Zoom might accommodate her better. Friday, April 18, 1:15 p.m. will be the Wendy Scott sentencing. All right. I think my assistant will go ahead and notify court services at the conclusion of this hearing. I know Ms. Scott's not in a position to meet with them or call them at this time. And I think she can give them the basic information regarding the need for a pre-sentence investigation and report. So thank you for doing that, Mandy. Friday, April 18, 1:15 p.m. for sentencing in the Wendy Scott case. All right, Ms. Norris, is there anything else that we need to address currently regarding Wendy Scott?
No, Your Honor. Thank you.
Mr. Watts, anything further at this time?
No, Your Honor, thank you.
Very well. Ms. Scott, you have any questions about what we've done here today?
No, sir.
Very well. Then if there's nothing further, the Wendy Scott matter will currently be in recess. I'm sorry.
Asking my lawyer, can he come and see me too?
I can.
Case number 2024 CR 346. Amber Norris appears for the state of Kansas and the Butler County Attorney's Office. James Watts appears as defense counsel. The defendant, Wendy Scott, appears from the detention center's Zoom location. This matter comes before the court at this time for sentencing. Court's docket notes indicate that Ms. Scott appeared before this court on February the 21st of 2025. At that time, the defendant pled no contest and accepted conviction for count 1, apparently as amended, kidnapping, a level 3 person felony, count 3, criminal threat, a level 9 person felony, and count 4, aggravated robbery, a level 3 person felony. A pre-sentence report was ordered and sentencing set for today. Court has received a pre-sentence investigation report compiled by Jessica Morgan, pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history as stated in this report?
No, Your Honor.
Is there any objection by the defense, Mr. Watts?
I've reviewed it with my client, Your Honor. We believe it is correct. Have no objection.
The court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to the primary count in this case is criminal history score B, and the court will proceed further accordingly. Ms. Norris, do you know of any legal reason why sentence should not be pronounced in the Scott case here this afternoon?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, Your Honor.
Ms. Scott, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing today?
No, sir.
We'll proceed further then. Regarding sentencing related motions, this court is aware there has been a motion entitled Motion for Durational Departure submitted by the defense. The court has a copy of that before it. Mr. Watts, you may proceed further in regards to this motion.
Thank you, Your Honor. Your Honor, I'm not going to go through the entirety of the motion. The written motion is there, and I'm sure the court has read it thoroughly. I want to speak only to basically a couple of parts of it. As I noted in the motion, this is a case that my client, and as I've noted right from the beginning, my client knows full well this is not what a court wants to hear at a time of sentencing. I've heard Your Honor in other cases specifically speak to this very issue, so we knew what we're kind of getting into when we say it. But my client has argued from day one and alleged from day one she did not commit this offense. That continues to be her position. And that continues to be her position despite the plea entered in this case. And I will focus only on a couple of things as part of that. I had occasion to have a phone call. The most important part of this is Sierra White. Sierra White was a person over in Wichita who I spoke with on the phone at one point. Ms. White told me at one point during that phone call that a car came by, the car that was stolen in this case, and picked Ms. Scott up, that Ms. Scott had been with Ms. White during that time. However, I know full well that me relating a phone call to the court is not admissible in court. There's no way that by itself is going to be sufficient. I spent 5 months with a private investigator attempting to locate Ms. White. And it's just very clear that over the course of that 5 months, Ms. White did not want to be located. The private investigator had occasion to go to her house, speak to, if I remember correctly, a daughter, but Ms. White was never there, was never where she said she was going to be. My investigator spent, I don't know exactly how many times, but 5 months of attempts to contact Ms. White. And as I made it clear in the motion, Ms. White apparently didn't want to be contacted for a couple of reasons. One, she had apparently had a warrant out. I, of course, as in my circumstances, don't care at all about the warrant. That's not my concern. But the other is in the world that Ms. White lives in, and to a certain extent, the world that Ms. Scott lives in, I'm certain, is not the same world I live in, and perhaps you live in, Your Honor. In Ms. White's world, police are not to be trusted. Police are not to be, authorities are not to be cooperated with. That is not assistance, that's betrayal. So Ms. White was unable or unwilling, maybe a better way to put it, unwilling to come forward. Without that confirmed witness, which would have been an alibi witness had she been able to come forward, had she been willing, maybe put it more accurately, had she been willing to come forward, this case was simply not viable to try. I discussed that with Ms. Scott, and she made a determination that she did not want to continue to find Ms. White, to continue to pursue a defense, but rather would simply resolve this case by plea. In doing so, she saved the state and the court significant time. She gave up not only the ability to defend this case in court, but in any realistic sense, the ability to appeal it as well, as I discussed with Ms. White. So, as I said, I'm not going to go completely through the motion and not going to get into the details, but I thought that needed to be spoke to. And as I started from the beginning, my client and I understand that is not what courts want to hear at time of sentencing. It is, however, the reality, Ms. Scott's position in this case. Frankly, I don't know, had we been able to secure Ms. White's testimony, how this case would have gone. That is speculation. Had her testimony been consistent with what she at one point spoke to me on the phone, there may have been an alibi witness, and a viable alibi witness. But given the certain reality, that was not possible. One of the bases for a departure is that there was a valid and defensible witness, valid and viable defense, even if a jury did not accept it. Now, this is not that case where a jury did not accept a defense. This is a case where the defendant was unable to put on that defense because the witness necessary to that defense was unwilling to come forward. For those reasons, and again, I'm not going to get into the rest of the motion at this point, we would ask the court to consider a durational departure in this matter if not a dispositional one. I'm not asking for a dispositional departure, but a durational departure in this matter. Thank you, Your Honor.
Well, it's a question from the court. Even if this Sierra White could be located and testified in the manner in which you described, that she saw Wendy Scott being picked up in the stolen vehicle, that doesn't mean necessarily that Ms. Scott wasn't involved in the original taking of that vehicle, because this obviously would have been much later than the actual taking. True?
No, Your Honor, it is if what Ms. Scott also told me that she had been with Ms. Scott that day and had been with Ms. Scott all that day. It was picked up later that day. If that is in fact the case. Now, again, I have no way to know if that's the case because she was unwilling to come forward and be interviewed and take part in this case. We believe this would have been, again, were we able to interview her and were she able to come forward? This may have been an alibi witness. We can never know that with any certainty, of course, because she was unwilling to come forward.
Very well. Anything further on the departure motion, Mr. Watts?
No, Your Honor, the motion speaks for itself as to the remainder.
All right. Does the state wish to make argument in regards to the departure motion currently before the court? Ms. Norris.
Your Honor, keeping with the plea negotiations, the defendant was allowed to ask for departure, but there's no agreement, and nor was the state required to join necessarily. Your Honor, I find the bulk of the motion to not even really sure what to call it. It seems like maybe a work of fiction. There was no trial. This motion is the first I've heard of any alibi witness. None of that information was ever provided prior to this motion. And I really think it has zero bearing on the sentencing at this point. The defendant pled. And we negotiated the plea. Again, none of this was ever talked about. I feel, or the state's view of this, along with some other issues in this motion, is that, and defendant actually pled no contest, is that the defendant is unwilling or possibly incapable of taking responsibility for any of her own actions. So, like I said, she pled no contest. Now we're having a discussion about a possible alibi witness, which is irrelevant at this juncture. And I would also note let's see, I guess it's bullet point number 7. That she apparently has told her attorney that the reason she's B is because of this flee and elude aggravated battery from 2020, which is 5 years ago, which is not that long ago. That she was a passenger, and that basically we don't even know how she ended up actually being charged. Well, that is completely inaccurate. She was the driver. She fled from law enforcement and she hit a police officer while she was fleeing. And that's directly from the official version in the PSI from Jackson County regarding the case and the conviction. So she's obviously, I assume that she told Mr. Watts that, she was the passenger and that she wasn't responsible for any of that. And so that's what he put in his motion. And again, back to not taking responsibility for her actions. So, I would ask that the court deny the request for any form of departure. We basically had spoken that we would recommend the mid-box presumptive sentence, and that And so we would be requesting that the court follow along with that plea negotiation, which is what we previously discussed. And does the court want recommendations at this point additional to that? And I also wanted to let the court know that the victim and a member of her family would like to address the court as part of sentencing today too.
Ms. Norris, the court will take up the state's formal recommendations a bit later in this proceeding.
Thank you, Your Honor.
All right. Having heard from both parties on the departure motion, at this time, the court will ask, does the victim or any member of the victim's family wish to address this court in relation to the Wendy Scott sentencing? Ms. Zielke, I see Zielke on the screen. You're muted currently. So if you'll turn on your audio and then you can make your statement to the court.
Can you hear us now?
I can hear you.
Okay. Okay.
Now what?
Ma'am, I'd first ask you to state your name.
Beverly Zielke.
Do you have a statement to make to the court?
I sure do. I'm the one they threw in the road and drove off in my car, my brand new car.
Okay.
That
All right,
still
ma'am.
had a paper tag on it. I never even had time to get a tag yet.
What do you want to say to Wendy? To Wendy?
Am I to speak to her
Yes.
now
You,
or what?
you can make whatever statement you feel is
I
appropriate.
cannot believe she did what she did. They played me for a fool. She was a neighbor. Her other friend was a neighbor. And she showed up at my house. I'd never met her. And she said, is she here yet? And I said, here? And she named the other girl. And I said, no, she was coming to borrow a cookbook. And she said, can I come in and wait
You're
for?
talking to Wendy. Tell Wendy what-
Dr. Wendy, not.
Let's let Ms. Zielke
He
make
knows
her
what
own
happened.
statement, please.
Am I doing it wrong?
Just tell
I've
me
never
what
been
you
to
wanna tell
court,
Wendy.
so I don't
You're doing
know.
fine, ma'am. I just don't want anyone else saying anything in the background or anything like that. I want you to make the statement, Ms. Zielke.
Well, I am.
Okay, go ahead.
And she took, and then she started rolling on the floor and Wendy said, could you take us to the emergency room? She's having a bad time. And I said, well, yeah, I can take you. I can't go in because I'm babysitting my daughter's dog because she took a cruise and I'm babysitting. So we got in the car and Wendy sat in the back seat. The other girl sat in the front seat. And they had me turn, when you go to Andover, I thought we were going to Andover, and she said, no, turn. It's two roads before you get to Andover. And I drove on a country road. And I drove and drove and drove and drove and drove. And I said, where is this place you want to take her to be? Because she started, when she was in my house, she started rolling on the floor and saying her stomach was killing her. And Wendy says, oh, she needs to get to the emergency room. Could you take us? And we drove and drove. And I finally says, how much further is this place? And she said, we're almost there. It's not too much further. And I drove and drove. And then I finally stopped the car. And I said, well, where is this place? We've been on the road a long time. And she held her purse up and she said, see this purse? And I said, yes. And she said, I have a gun in it. I have used it before and I'm sure not afraid to use it again. And then she yanked my car door open and she started pulling my arm, and the other girl was in the front seat on the rider's side, and she was pushing me on my back trying to make it. I was hanging onto the steering wheel and trying to stay in the car, and they were yanking and pulling. And Wendy had long fingernails and they were painted, and she kept pulling on my arm like this. And I had her nails went through my skin from here clear down to my wrist. My whole arm was bleeding because her fingernails had went all through my skin, all around my arm, because she was trying to pull me out of the car. And she finally won. She pulled me out, and I had my daughter's dog in the car with me, and I didn't know if they threw me down in the dirt, and the dirt, my whole arm was black because it was bleeding with blood from top to bottom. And I was scared I was going to die because she threatened me with a gun. And it scared me to death. And after they threw me in the dirt on the country road, they took off, and they had my purse. They spent $1,000. They used a credit card. I think they bought gas. And I had to walk. I walked to one place and they weren't home, and I walked another down in the next mile. And I finally came to a family that was home, and they called the police. And then the sheriff and the police and the fire station, the truck all came. They wanted to know if I wanted to go to the hospital, which I said no. But they cleaned my arm and disinfected it. The whole arm had her fingernails had gone through my whole entire arm. It was pure blood. And I was terrified. All I did is I was going to take her to a hospital because she said her stomach was hurting, and she's rolling on that mat floor back where the cookbook was in my house, the other girl. So I don't know. She never, ever, ever said she's sorry. She hasn't to this day. I went through a lot of hell with that, and I've never done anything in my entire life. I've never been in trouble with the police in any way in my entire life. I couldn't believe all of this was happening. All I was going to do was help them, because she was crying, and they asked me to take them to the emergency room. And I said, of course I'll take you to the emergency room. I don't know what else to say. You do want to have a question for me?
Ms. Zielke, the court would just ask you, is there anything else that you wanted to say to the court today about Wendy Scott's sentencing?
I think she's the one that took my car and drove it. Was the driver. She took my car and pulled me out into the dirt. And I didn't know if they took little Chloe or not, because I had my daughter's dog in the car. I didn't find that for another week. I thought she was gone. I thought they had taken her, but they didn't.
Okay, so was the dog recovered then, Ms. Zielke?
Yes, finally, yes. And they had a month later, it was about 3 weeks later, and a farmer that he was at their house, and they had made when you on the dog pound thing, they had left message that there was a dog, and we thought it sounded like Chloe, and so we went there, and it was Chloe. So we did get the dog back.
All right. Anything else?
I just I just can't believe that they did that. I just can't believe that she did that. They just threw me, and I'm 87 years old. I'm 87 years old. And they threw me in the dirt and threw me out of my car, out on a country road. I think she deserves to pay for something, because I cannot believe she did. I can't believe anybody would do such a thing to anybody. I don't care their age. I can't believe they would do such a horrible thing. There was never anything bad to them. Everything they did was to hurt me. And I didn't realize that.
Ms. Zielke, thank you for your statement to the court. Just so
Thank
we
you
can
for-
eliminate background noise, could you go ahead and mute yourself again, ma'am?
Muted by
Mute.
that one. Okay, are we muted?
Is
Yeah.
it done now?
Yeah.
Not yet. Okay, I think you are now. Thank you. All right. I'm going to perceive here that there's no other members of the victim's family who wishes to address the court.
I think maybe there is, Your Honor.
Okay, then if it's the person who's with Beverly Zielke, if they can go ahead and unmute themselves.
Unmute. Okay, now say that again, please.
No.
Are you a member of
Yes, I'm her
Beverly's family?
niece. I am her niece.
Did you have any
And I've had
statement that you wish to make to the court?
Yes.
All right, first of all, state your name.
Wendy K. Dwyer.
All right, Ms. Blyer, what is your statement?
Dwyer, D-W-I-R-E.
Okay, thank you.
Okay. All right. First of all, my aunt clearly remembers Wendy Scott's face and clearly remembers Wendy Scott being in the apartment. This is my turn. The reason I felt it was important to speak to Wendy Sincere Scott is because I want Wendy to truly understand how horrific the crime she committed with her friend Elizabeth really was. Wendy, the reason I feel you need to hear this is because every Zoom court I watched, you never was concerned about my aunt. You were very concerned about yourself like you are today. My Aunt Bev is 87 years old, and you never once stated you were sorry, and you knew there was a good chance she was watching those on Zoom, but you never had any remorse about what you did to her, and that tells me a lot about you. You totally made a plan with your friend Elizabeth, who happened to live in the same building previously, to reach out to an elderly lady about a cookbook, and then your friend following through with y'all's plan to create a medical issue to get my Aunt Bev into her car with the two of you. This was totally planned with no remorse or feelings about it. Then you threatened her by telling her you had a gun and wasn't afraid to use it before pushing and pulling on her to shove her out of that car and leaving her on a country road, and took off with the car, the purse, a dog, and then bought 4 cell phones with her credit card, and then go joyriding in the car with not a care in the world. The fear and trauma this has caused on my aunt is horrible. She has lost all trust in people and now lives her life in fear. What you and your friend did shows your character and who you are as a person, which is downright cold with no feelings at all. I hope you take the time away to reflect on your life and all the lives you have hurt along the way. I also hope your grandma, mom, daughter, aunt, or whoever it may be never has to go through this scary, traumatizing experience that my aunt had to live through and continues to deal with every day. That's what I had to say. I'm done.
Very well. Thank you, ma'am. If you'd go ahead and mute yourself again, please.
Oh,
All right, I see that they have muted themselves. So at this time, the court will ask for recommendations from counsel regarding an appropriate sentence. Ms. Norris, at this time, the state may make any formal sentencing recommendations.
Thank you, Your Honor. Regarding count 1, the kidnapping, would ask the court assign defendant to the mid-range guideline sentence of 216 months in the Department of Corrections. On count 4, the aggravated robbery, 59 months in the Department of Corrections. And regarding the criminal threat, 6 months in the Department of Corrections. Overall, defendant would be able to earn up to 15% good time credit and would be subject to 36 months of post-release. As previously discussed, this is a registrable offense, although defendant will not need to register while in custody, but upon release. She has earned 269 days of jail time credit as of this date. Your Honor, we'd ask the court assess the cost of the action to the defendant. The court will need to make findings regarding the court-appointed attorney's fees and the bid's application fee. There is no request for restitution, and state is not requesting a fine as a condition in this case. Otherwise, Your Honor, I don't think state has any further recommendations for the court at this time.
Forrest, what's the state's position regarding consecutive or concurrent sentences on the 3 counts?
Your Honor, in keeping with the plea negotiations, it does appear that we discussed concurrent mid-box, follow the presumption. And that was via email prior to the plea on February 21st.
Very well. Thank you, Ms. Norris. Mr. Watts, at this time, I would ask you as defendant's counsel to make recommendations regarding an appropriate sentence. Mr. Watts, you are muted.
Your Honor, as to count 1, we'd ask the departure to half what are the otherwise granted sentence for the reasons previously noted. I would note, response to Ms. Norris, and I think something mentioned in court at the time we set the plea deal. We set not the plea, but the trial date where it was in February from a October preliminary hearing, in large part in order to attempt to find the alibi witness that the state believes is fiction. Moreover, I'm not required, nor would I, inform a defendant of any potential alibi witness until that witness is actually secured. As to the matter in Jackson County, I understand that's the state's position. I have no knowledge of whether that's accurate or not. In any case, as to the aggravated robbery, would ask the standard mid-range. In that case, we'd ask they run concurrent pursuant to the plea agreement with count 1. And as to criminal threat, the standard mid-range, and again, pursuant to the plea agreement, concurrent to count 1 as well. I don't think I have anything else to add, Your Honor.
Very well, Mr. Watts. At this time, the court will address the defendant, Wendy Sincere Scott, personally, and the court will ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she personally would like to present. Ms. Scott.
First off, I'd like to apologize. I never got the opportunity to apologize to Ms. Zilke of any of these crimes that was committed. Every time I was in court, I basically let my defense attorney talk for me. But from the bottom of my heart, what I was involved in, I do apologize for that, because I know I was in the wrong and I was very drugged up, but I don't want no oh poor me situations like I explained to my defense attorney. It never was oh poor me. I do apologize to Ms. Zilke for everything that was committed, that she was harmed. But what I had something to do, whatever I did in the situation, I do apologize for that. And nobody should have to, go through anything like that. So that's what I like to, inform. And that's all I like to say, Your Honor.
Very well, Ms. Scott. At this time, the court will pronounce sentence Ms. Scott, it would be difficult for this court to listen to a victim statement like made by Beverly Zielke and not feel some level of compassion for this elderly woman and what she went through. The actions of yourself and your co-defendant in the view of this court were utterly reprehensible. This is a woman who tried to reach out to you with kindness based on what she perceived was a legitimate medical issue. And in return, what she got in response was deceit, violence, and theft of her car. It would be difficult to imagine a more severe situation for these crimes than this. I think that we all should feel fortunate that Beverly was not hurt even more than what she was. But the court, considering all factors in the case, first of all, we'll just make a finding here for purposes of the record that the court, having considered the entirety of the motion for durational departure and all of the reasons which are stated and have been argued by Mr. Watts in this case, court finds that there are no substantial and compelling reasons that would justify a departure sentence in this case. With that said, the court hereby establishes count 1 as the base sentence for the offense of kidnapping, a severity level 3 non-drug person felony, in which this defendant has a criminal history score of B, thus placing her in grid box 3B. The court hereby sentences the defendant to a term of 216 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 15% of good time credit and would be subject to 36 months of post-release supervision. The court imposes no fine on that count. Regarding the additional offense of aggravated robbery, a severity level 3 non-drug person felony, in which the defendant has a criminal history score of I, thus placing her in grid box 3I. The court hereby sentences the defendant to a term of 55 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 15% of good time credit and would be subject to 36 months of post-release supervision. No fine is imposed on that count. Regarding the additional offense of criminal threat, a severity level 9 non-drug person felony, in which the defendant has a criminal history score of I, thus placing her in grid box 9I. The court hereby sentences the defendant to a term of 5 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court imposes no fine as to that individual account. Ms. Scott, with this court's finding that this was a terrible, avoidable, reprehensible crime, this court will run the time on counts 1, 4, and 3 consecutively with one another. This court of the belief that each one of these offenses constitute a separate criminal and violent act involving Beverly Zielke. And therefore, each one should be punished separately, and the court will run all 3 counts consecutively with one another. Doing the math here, the 216 months on count 1 is run consecutively with the 55 months on count 4. That would add to 271 months. There is an additional 5-month sentence on the criminal threat, which makes a total sentence of 276 months in prison. Ms. Scott, the primary controlling post-release supervision period is 36 months. No fines are imposed. However, the court will assess a felony docket fee in this case. Further, there is a statement before this court that indicates that there was a $1,000 in loss to the victim, Beverly Zielke, in this case. Whether the state's requesting restitution or not, this victim is entitled to it. So the court will be ordering the defendant, joint and several with any co-defendant, to pay $1,000 in restitution to the victim. Court declares that all amounts that have been assessed in this case are immediately due and payable and may be collected through the court's collection agency if necessary. Regarding jail time credit, the court does award, and the sentencing journal entry should reflect 269 days of jail time credit that the defendant is entitled to for being incarcerated prior to today's sentencing date. I will advise the defendant of her obligation to register as a violent offender under the Kansas Offender Registration Act. Court does find that with the crime of kidnapping in this case, that the period of registration in this case is for lifetime, which means all times that you're not incarcerated, you're going to have an obligation to register as a violent offender, Ms. Scott. At some point in the future, you may have the right to seek expungement of one or more of these offenses. Certain statutory limitations do apply. Ms. Scott, if you have any questions about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant may have a right to appeal a conviction or convictions to an appellate court having jurisdiction. If they are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 22-3608C, you, Ms. Scott, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence. If the court has ruled adversely to you at this hearing, I will remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Norris, are you aware of any other sentencing-related matters that the court has not yet addressed?
No, Your Honor, thank you.
Mr. Watts, are you aware of anything further?
No, Your Honor, thank you.
I do want to make sure, though, I think it could be implied from the record, I want to make a specific finding that based on the court's incarceration order, the court's waiving bids assessments in this case. The defendant just doesn't have the financial resources to reimburse those amounts. This time, the court places the custody of Wendy Scott back into the jail under the custody of the Butler County Sheriff's Office until her custody can be transferred to the Department of Corrections to serve the remaining balance of the prison sentence, which the court has imposed here today. If there's nothing further, the Wendy Sincere Scott matter will currently be in recess, and this meeting may be ended for all at this time.
Okay, Mr. James. Can we talk? Can they get out of here?